Good afternoon. It's 1:38 p.m. Central Standard Time on October 14, 2023. My name is Colleen Crouse. What I'm about to show you is in a folder of the case 3:cv-02126-K-BH from beginning on September 3rd, 2021. This folder is in another specific area portfolio that is the case material and the evidence from that case for over the last 2 years. However, this folder is the specific documents that are supposed to be on the docket for the court, including certain exhibits that are evidence, and what has been acquired in the last 24 hours, as well as the last 72 hours, in connection with the actual proceeding and what has already been determined. Understand that when I pulled this out, these specific documents from the overall portfolio, I kept them in the order they were in the portfolio. I have not altered the order in these documents in terms of the argumentation and the evidence that has been accumulated over the more than last 2 years. I'm going to briefly describe these documents at this time. This right here, as you can see, September 9, 2021. It discusses the consideration and how it was that a magistrate judge was allowed to be identified in connection with this case. I have here, this is the information that was available on the court website regarding the judge who was assigned as the presiding judge and the requirements in consideration of his authorization or his relationship to a magistrate judge. They were not met at any time. This document, you can see the date that I printed this out, is supposed to be in connection with admission requirements and application as a member of the bar of the federal bar for the Northern District of Texas U.S. District Court. There is also this identification pro hoc vis appearance in consideration, again, of the considerations necessary in order to be representative in a case proceeding before the Northern District of Texas U.S. District Court. Here you can see this right here, another copy of the civil cover sheet in connection with the case. This one has not been filled out. There are other ones. This is emblematic of the first ones that were submitted. I acquired this at that time. There will be another, you will see this coming up again. This is an email identified 9/27/2021. This is a specific explication of the charges regarding the invocation of Article 16, Section 50, September 27, 2021. This was sent, as you can see, the emails it was sent to, including opposing counsel, and the email address I was given for the court, as I had asked for special consideration in lieu of my material circumstances in order to be able to submit motions and filings through an emergency process, which was granted. As you can see, I outline here the specifics regarding the case. Not only the case, but the citation of the specific statutes as part of the Constitution. Not only that, I emphasize the areas that are actually of material concern in the context of the argument, as you can see. And then I say every single element of this article as it applies. Understand there is a timeline in here that is up to 2 years. We just finished a 10-year timeline, and the specifics regarding numbers of days, including in consideration of illegal loan arrangements and illegal lien arrangements, have all been tracked and verified over the course of the last 2+ years, including up through the last week, even as recently as last night. Okay, and as you can see, I emphasize this specific element in this formal communication with the court, which was acknowledged as having been received. It's page 3. This is page 4. Again, these were the areas that were repeated and emphasized. You can see, then I go ahead and I make the explication. Then I say, identify the evidence, confirm, timeline, specifically the charges as they were outlined, what the information was, the understanding of the proceeding, where we were at this point on September 27th, 2021. Then I say, I continue talking about the charges. I continue by identifying the events that occurred, the infractions of the law, the specific elements of what it was that was also of concern, including the conduct of the judges at that point in time. I requested an injunction, and then I also followed up by identifying the location where this was submitted and attesting to my state of mind as well as my authority and the legal context under which it was submitted. Please understand, I want you to see this. In every email I send, I include this in the signature line. Quote, by receiving this message, you are informed that the sender has no intention of receiving, sending, distributing, or redistributing any pornographic content under any circumstances. That is one of 4 paragraphs identified in the signature of every email I send anybody, even if I am tracking my own electronic accounts, and I send emails to myself. Every single email that has ever been received by me or that anybody else has received from me has this signature line. You were all duly warned. This is from what was supposed to have been the document that was filed in connection with the alleged eviction petition regarding State of Texas Eviction Diversion Program. However, in the context of the presentation of the petition for eviction, this did not apply except for this, dated March 8th, 2021. There was also a version of this that was submitted in Spanish. This is from the original case. This is material from the original case involving the petition for eviction. This right here is a motion on failure to establish title submitted in this case, received by the court October 21st, 2021. In this, when I composed this, I sent it. I had it verified by the court, and this is the version that was formally acknowledged by the court, including different elements, as you can see in the formatting, identifying no legal right, and also discussing the context of the acceptance of the appeal and the constitutional grounds on which to accept the understanding that there was nothing legal about the process, including as it was commenced or what was attempted for in the context of whatever was supposed to masquerade as legal process, which was not the entire time. And I also say, as a matter of evidence, see U.S. versus Felix, regarding same evidence can be used to prove more than one charge. And then I identify a list of evidence, evidence list 2, motion to add exhibits to evidence list 2, and evidence list 3. This was from October 21st, 2021. I also printed it out and I signed it and dated it myself at the time. Now, this one is dated for the 30th of November, 2021. At that time, I printed out 3 copies of this. Why? This one is dated for November 30th, 2021. That was how many days after November 1st of 2021? Continuing. This right here is information that was also identifiable as evidence regarding Texas House Bill 219, prior legislative session, relating to the extension of the expiration of certain parts of the Texas Economic Development Act. I identified this as evidence. This is from the Texas Health Code, elements of the Texas Health Code, including elements of the Texas Health Code that were already identified, including in connection with reports I'd already filed to the Texas Health and Human Services Commission. This is regarding Texas House Bill regarding electric utility transmissions and smart meters that were of material concern and were already identified in the affidavit submitted to the court. I also contended that this was evidence in connection with the charges, including the identification of motive. Now, these ones are presented in this manner for the particular reasons. This is white sheet. This right here, again, motion of failure to establish title. This is a second copy. You can see this second copy right here, of this version here. Same version, it was just merely printed out 3 times at the same time. This one here, as you can see, it's not yet been signed. There's a reason why. Next, other evidence that was requested for consideration. This evidence was at least allegedly accepted by the court. H-Res 18A, providing for consideration of the bill H.R. 842 to amend the National Labor Relations Act, the Labor Management Relations Act 1947, and the Labor Management Reporting and Disclosure Act of 1959, and for other purposes. Providing for consideration of the bill, H.R. 8, to require a background check for every firearm sale. ... There is specific information in this bill and how at the time on March 7th of 2021, I had made a public indication in a video that I put online in preparation for a committee meeting for this and other matters regarding a committee process whereby they were discussing obtaining inventories of firearms that I allege has been used to create collateral and lists of collateral that have been used in illegal processes, including under the auspices that Congress authorized it, dated for March 8, 2021. I contend the city of Dallas absolutely knew, and it was 100% intentional. This was entered into evidence on a list of evidence. I will show you the list of evidence. The list of evidence was also recently identified. This is the indication of the time I printed this out as evidence and for when it was submitted. This right here is an email to 2222, February 22nd, 2022. This was in connection with my efforts to prepare for an appeal in another case that I allege this case was used as an illegal proceeding in order to obstruct and also as retaliation for filing that case, which presumably was dismissed formally and officially, and was support for this dismissal was provided by the presiding judge on April 16th of 2021. This is a review of legal precedents going all the way back to, among other things, information that was provided by Thomas Jefferson concerning matters that were identified in the summary review of the rights of British Americans. I contend that part of this proceeding is attempting to violate the Constitution, and in so doing is trying to expropriate from people from who are out of state matters pertaining to their birth origin in another state, and this is part of the evidence. This right here is November 13th, 2021. This is in connection with the original argument. This is my original review of what was just identified and the argumentation of how this factors into the case. There was more follow-up, you can see, a comprehensive review of this that I time and date stamped by actually emailing myself. Again, more. This again, printed on the 22nd of February, but was actually provided on November 13th of 2021. This is a continuation of the argumentation based upon a review of that specific legal authority. Again, more. This is the digest, the time and date stamping of all of the arguments, almost as if to say, were there to have been an oral argument or there to have been a hearing. This is what and how it would have been presented. Again, you can see more context to the argument in the actual succession to the arguments is already presented, as you can see. Okay, all of this was by the before noon on November 13th of 2021. Here also printed out that time is, again, a follow-up, because I re-reviewed it on December 10th, 2021. At that time, I also reviewed other historical documents that I believe were being misabused, and that the indications of the intent to misabuse them had already been presented in the autumn of 2016 and beginning of 2017 in Houston, Texas. This is another follow-up from another source that I used in preparation for the appeal, from a book called The Art of Power, about the history of Thomas Jefferson and specific kinds of proceedings that had been commenced that provided substantiation and support to the information in this particular argumentation regarding a review of the summary review of the rights of British America. And then there was a second, reaffirmation of that. This right here is specific motion. Notice of election regarding consent to proceed before a United States Magistrate Judge. That was actually submitted in this case number on September 9th of 2021. What does it say? Acknowledges the availability of a United States Magistrate Judge to try this case or rule on dispositive motions, but chooses not to consent to proceed before the Magistrate Judge. Do you see that? Chooses not to consent. Check. date, signed, turn in the case. Now, there's much more here, as you can see. I contend not only did I prove the entire case, but over and over again it was proven, and the fraud is so extensive, this is where we are. I need you to see something. Where did this come from? Where did this come from? Where did this come from? Right? We can't say the case is closed because nobody ever attended to the case under the actual law. Nobody actually did due process. It was never constitutionally engaged, was it? Was it? You put it in the wrong name. Do you understand? Her name should never have been on it. Now we're in a situation where I need all of the title returned to me. Do you understand? It is before 2 o'clock p.m. on October 14, 2023. My name is Charity Colleen Crouse. You were already informed.